Hey everyone, welcome to another edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me as he does every other Friday from Southern Indiana, Alex Ooley. Alex, of course, the host of the Forge of Freedom podcast and also an attorney at the Ooley Law Offices there in Southern Indiana. Alex, thanks for coming on the ride today. How are you doing, man?
I'm doing well, Paul. It's great to be with you. You doing okay?
Doing great, man. Doing great. Looking forward to 2 weeks from today. We are going to be spending our second day in the U.S. Virgin Islands. Susan's already got us packed up, ready to fly. We're just waiting on time to go to get here. So, not that we're excited about it or anything.
Well, it sounds like you're in good hands. Susan's got you ready.
She does. She does. All right, as we get started here, I want to remind everybody, if you are watching us live on the Polite Society podcast, Facebook, or YouTube page, go ahead and comment on those live videos. If you're watching us anywhere else, to get your comments into the show, go to Twitter, tweet with the hashtag #TheBullet. A little bit of legal that I wanted to talk. The major story in Second Amendment that has hit over the past 2 weeks since you've been on to talk legal with us is the Fifth Circuit decision. There are two Fifth Circuit decisions. The first one, that if you've been convicted of domestic violence but it's not a felony, you still have gun rights. Second one is that the federal government cannot say because you use marijuana that you cannot have a firearm anymore. That only, of course, Fifth Circuit decisions only apply in the Fifth Circuit. For those of you who are not familiar, Fifth Circuit is Texas, Louisiana, Mississippi. That's the Fifth Circuit. Again, Alex, anything you and I say is not legal advice, but how does that change the 4473, or does it, or do you not have to answer if you're living in the Fifth Circuit and you go to buy a new firearm? Because there is that question on there.
Yeah, so with respect to the marijuana question, it's not going to change the answer. So if you're looking at the Form 4473, it's 21G, and it asks are you an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance. So this court case doesn't change the answer to that question. What it does change potentially is whether or not you are a prohibited person as a result of your answer to that question. And that's something that the FBI and the courts are going to have to wade through. In the Fifth Circuit and a few other courts, I think, are going to come down on the side of the right to keep and bear arms in that regard. So I think this is an issue, a lot like many of the other issues being challenged in the courts right now, that will remain unresolved until the Supreme Court ultimately opines on the issue.
Yeah, and we're generally what has to happen, you and I have talked, and you've said in the past, what helps it get to the Supreme Court is if there's a split in the circuits. For example,
that's right.
the Ninth Circuit says, yes, you can be prohibited, and the Fifth Circuit says, you cannot be prohibited. That will speed it along and increase the chances the Supreme Court will take it, right?
That's right. The Supreme Court takes a very low percentage of the cases that they are asked to review each year, and they have to prioritize those cases. And taking circuit splits is one way that they prioritize those cases. Like you said, if there is disagreement among the intermediate courts of appeals, so between circuits, then the Supreme Court is more likely to resolve that discrepancy so that there's consistency in the application of the law throughout the country.
Absolutely. And as usual, we've got viewers that are extremely psychic. 500 Magnum knows what our next topic is going to be. He says, Paul, have you heard that Measure 114 will not be going into law? Congratulations, Oregon. That is one of our next stories we have up. I got the news off of OPB, Oregon Public Broadcasting.org. ballot measure 114's provision remain blocked in their entirety pending a lower court hearing on the measure's constitutionality. Basically, the Supreme Court of Oregon has said, no, we're not going to let you enforce this until it's through its process, and no, we're not going to take it right now because it's not up to us yet. It's still in lower courts. This seems to me substantially similar to what the Supreme Court has done with New York. They had an opportunity to step in, but they said, no, let the Second Circuit handle it. And by the way, Second Circuit, expedite what you're doing. It sounds a lot to me what like the Oregon Supreme Court is doing here. What do you think, man?
Yeah, I think you're right, Paul. I think that's partly what the Oregon Supreme Court is up to here, that they want to let the case play out at the lower court levels, let all the facts come out, let the courts let the parties do their briefing, submit their proposals and their arguments before the Supreme Court steps in and intervenes in the case. Fortunately, while the case is pending, unlike the New York case and the Second Circuit, the case is favorable to the citizens of Oregon, unlike the citizens of New York. But you're right, in terms of court sort of procedure, I think there's a similar approach going on here.
All right. Next story I've got. This actually is three different stories. One off Texas Tribune, one off WBIW, which is an Indiana news source, and then one off Bearing Arms, a Cam Edwards story. It looks like a whole bunch of states, and I'm assuming these are all about the same lawsuit. I may be wrong there, but a whole bunch of states and at least the GOA have joined together to file a lawsuit against the pistol brace rule that came out of the ATF. And by the way, the SAF is already there, or the lawsuit's already filed. Am I right there that all three of these stories are basically the same lawsuit?
Yes. Yeah, and it's promising to see that there are so many states and so many attorneys general jumping in and advocating for our right to keep and bear arms and against this administrative overreach. I think that clearly what the ATF is doing here is arbitrary and capricious, that they are going beyond their authority as a rulemaking regulatory authority. And I think that ultimately, the pistol brace rule will be struck down. But again, this is something that will remain unresolved more than likely until the Supreme Court opines on the issue.
I want to bring up specifically off the Texas Tribune story. There's one part in here that just kind of toasts my cookies, so to speak. After they explain a little bit about the lawsuit and about the middle of the article, they go, since January 1st, there have been 63 mass shootings. Now, in order to do that, they had to change from the FBI definition, where 4 people, not including the shooter, are dead. Now that their definition is which more than 4 people were injured or killed. And they also got their information from Gun Violence Archive, which is directly supported by Bloomberg and Demanding Mommies. This is something we really got to watch for, in my opinion, Alex, is they're trying to change the definitions on us again. There are no more mass killings than there ever were. They're just taking injuries and inflating them so that they look like killings.
Yeah, that's right. This is some of the sort of word play that they use to try to make headlines and try to promote propaganda in support of their position. And I think I would like to point out, too, that I know a lot of the listeners already know about John Lott and the Crime Prevention Research Center, but he has a lot of great resources on his website, crimeresearch.org, about mass shootings and about how the anti-gun crowd and the anti-gun organizations try to characterize mass shootings and how they redefine them to support their narrative. But one thing I'd like to point out, he's actually got an infographic on his website that shows how mass public shootings in America occur primarily in gun-free zones. And he says in this infographic that of all the mass public shootings in America since 1950, 99% of those occurred in gun-free zones. Only 1% occurred in a location where guns were allowed. So I think that obviously gun-free zones are targets for people who want to do evil, and that the best deterrent to somebody who intends to do evil is somebody who can respond with equal or greater force. And that's often going to be the armed citizen, because let's face it, law enforcement, as good a job as some of them do, can't be everywhere all the time.
Yeah, you're absolutely right about that. Last story in the legal area that I want to talk about, and this one, again, I just found out about recently. I didn't have enough time to get into show notes. But the last one in the legal arena is, and it's similar to the one we talked about in Oregon. The SAF and many others have filed lawsuit against Washington's anti-gun laws that are into effect, including the magazine ban. The Washington State Supreme Court yesterday turned down the appeal, or the request by the state to drop the lawsuit because it can't be heard until December. The state says that's not quick enough, so we want you to just drop it. And the state Supreme Court said, no, we'll keep going. You can't tell us how to handle our schedule.
Yeah, that's it's certainly good news out of Washington, and I hope that more anti-gun politicians and anti-gun organizations are held to task, and that the courts take up these cases.
All right. Oh, I lied. I just found one in the show notes that I'd actually forgotten about. We discussed it a little bit. Mike Piwowarski and I did yesterday. A story out of Iowa. A Des Moines school district student. One day the civics teacher, it used to be, when I was going through school, it was called government, but it's now civics. And the civics teacher talked about First Amendment rights. Next day, student, young lady, wears a pro Second Amendment T-shirt to school, and it's the T-shirt basically has the quote, "What part of shall not be infringed do you not understand?" with a picture of either it's a picture of a rifle. It's either an AR or it looks more like an M16 on the bottom of it. But the teacher said, I get to decide what's free speech in my classroom, and you're suspended. She's now, the mother's now suing the school district. Where I come at this from, Alex, and I may be totally wrong here, the school gets federal money to operate, gets state money to operate. In my mind, that makes it a part of the state, and the Bill of Rights, specifically the First and Second Amendment, are meant to hold back what the state, meaning in my thoughts, the school, can do. Am I way off base here, bud?
No, you're exactly right. In fact, Section 1983 claims, which are simply it's just a shorthand for civil rights claims that are brought under Federal Code 42 U.S.C. 1983 for violations of civil rights by government officials, and that can include school officials. We often think about them in the context of policing and excessive force, but they're often brought with respect to First Amendment violations. And the Supreme Court made clear decades ago, and the article talks about this case called the Tinker case, that students don't shed their constitutional rights to their constitutional right to the freedom of speech at the schoolhouse gate. And that case the Tinker case involved the students who were wearing black wristbands in opposition to the Vietnam War. And so they weren't speaking per se, but they were wearing clothing, which was a form of speech. And that's exactly what's going on here in this case. So I'm glad to see that the child and her mother are taking the school to task on this issue.
And this what's brought up in the story is that this teacher is also an adjunct professor at 2 local universities and has, let me go ahead and find it in the story. According to the complaint, Griffin is not the ordinary teacher when it comes to knowing and understanding students' right to free speech under the Constitution. Rather, it says Griffin also works as an adjunct professor of government and history at 2 nearby colleges, and was even named a James Madison Fellow, an award which came with a tuition assistant for his master's degree for his exceptional high school teaching of the Constitution. Griffin even published articles on First Amendment law, which Bristow quoted in her court complaint. This is really laws for me and not for thee. I'll write about it, and you have to follow what I say, or what I do, not what I say.
Yeah, this is just another example of someone with a lot of letters behind their name who still has no respect for individual rights or for people with differing opinions. So that's unfortunate, and I think all too common.
Yeah, a comment from the Facebook side. This is what happens when you take God and the Pledge of Allegiance out of the schools. Michael quoted that from the Facebook side. And I think, honestly, this guy, he's a professor. The First Amendment is not that much more difficult than the Second Amendment to read. He needs to be re-educated himself in that. This is not, she wasn't threatening anybody through her t-shirt. She wasn't saying, I'm going to blow up the school tomorrow on the t-shirt. She's just saying, I have a Second Amendment right, and using her First Amendment right to state that. And I'm glad there's a lawsuit going forward. Let me put it that way.
Yeah, and the courts have said that schools have some interest in restricting speech, but only insofar as it prevents substantial disruption, or that it prevents the promotion of illegal conduct, or is lewd or indecent or vulgar in some way. But there's a very fine line there, and I don't think there are any facts that I'm aware of anyway that this shirt or the child that was wearing it was being a substantial disruption or being lewd or vulgar or disruptive to the learning environment. And so I'm glad that the child and her mother are taking this up.
Right. To get on to the regular news, I got a news story from the Mountaineer.com. That's a North Carolina newspaper. Apparently there are a lot of gun-related bills going through in North Carolina. I'm going to read just a few of them. House Bill 50, an identical bill, Senate Bill 40, would repeal several sections of law to eliminate the state's pistol purchase permit. Right now it's in a Judiciary 3 committee, while SB 40 is in the Senate Judiciary Committee. House Bill 56 would create a tax exemption for equipment used to safely store firearms. House Bill 53 would prohibit gun owners from leaving a firearm in an unattended vehicle unless the vehicle is locked and the firearm secured. I don't know about that one. House Bill 36 would add qualified probation and parole officers to those who qualify for a concealed handgun permit without additional firearms training. And then House Bill 36... I'm sorry, House Bill 72, a bipartisan bill that mirrors Senate Bill 67, would create a firearms safe storage awareness initiative to educate the public about the importance of safe storage of firearms and to facilitate the distribution of gun locks. And I had a conversation with John Richardson, who's on the Polite Society podcast with me, and a resident of the Asheville area and heavily involved in North Carolina politics. His opinion is that the repeal of pistol purchase permit is a definite, most likely to pass. The votes to override an almost certain veto are there now. A tax credit for buying a gun safe, possibly. The bill to make it a crime to leave a gun in a car without a lockbox, he doesn't think has much of a chance of passing. Your thoughts on any of these, Alex?
Yeah, so I generally don't like safe storage laws. I think you mentioned one, I can't remember what the number was, about education, about safe storage. I don't see necessarily a problem with that. But this law, House Bill 53, and I haven't seen the exact text of the law, but a law that says that the firearm needs to be in a vehicle that's locked and the firearm secured. Well, the question is going to be, what does secured mean, and who's going to interpret that? And I think that a lot of those sorts of laws are subject to arbitrary enforcement, and I really don't like safe storage laws. Does that mean that I think people should be irresponsible and not store their firearms in a safe manner? Absolutely not. I think people need to be responsible and store their firearms in a safe and secure way. But I don't think that there should be laws mandating those sorts of things. I don't think they would be effective, and I'm worried about the way that they would be enforced.
Oh, absolutely. What it basically requires is somebody who's a victim of a crime, having their gun stolen, to be a victim again of the state. Because once they do the right thing and report their gun has been stolen, all of a sudden, you're a criminal and you might get a fine or jail time.
And I'm always in favor of reducing or eliminating taxes. So I'm in favor of that one for sure, the one that would give a tax incentive to purchase a safe storage device. So I like that one. And then obviously I'm glad to hear that there's the bill that would repeal the law requiring a pistol purchase permit is likely to get support. So I'm happy to hear that.
Yeah. Get a comment in here real quick. Big John 410 on the YouTube side says, every gun I've ever purchased, new or used, came with a gun lock. Well, I've purchased some used ones that haven't, but the good news is those cable locks that you get when you buy new from the gun store, they're really cheap to buy if you don't already have one. And I'm right with you, Alex. I think if you're not personally wearing your gun on your body, I think that thing needs to be secured or in a place where anybody visiting your house isn't just going to be able to pick it up and use it. I think everybody should be responsible with their storage of their firearms. I don't think it should be a law, and I think you can agree with me on that.
Yeah, absolutely. I don't think that the law will be a panacea and make people who were irresponsible before suddenly responsible. I don't think that the law is effective in that way, as a lot of politicians imagine that it is. And of course, these are often laws that are promoted or proposed because of a call to do something. And politicians they feel like they have to propose restrictive laws so that they can tell their constituents that, hey, there's this problem and we did something about it. Even if it's going to be ineffective, they'll go ahead and say, oh, we did something. And that's often where we get bad laws and ineffective laws like these safe storage laws. But I think that as gun owners, we need to be personally responsible, and that the more we are as a group personally responsible for our actions, including the way we store our firearms, the less likely politicians are to try to take away incrementally our right to keep and bear arms through laws like this.
Well, I just had an epiphany on something, and while you were talking about that, it's a self-fulfilling prophecy. The politicians, I've got to do something. So they do something to decrease our ability to defend ourselves. That makes crime go up. Therefore, more people scream, you got to do something. So the politicians do something that further curtails our rights to protect ourselves. Therefore, crime goes up. It's a vicious circle, and it's a self-fulfilling prophecy.
Yeah, and I think this is true in lots of areas, not just with respect to firearms. That's how politicians operate. They create a problem, they promise a solution to the problem they created, and the cycle goes on. And that's sort of the nature of politics to a great degree.
All right, last comment on this one. Michael says, those cable locks are not recognized in New York City. They require trigger locks. Stupid is what stupid does. I don't know. I'm not going to do it on YouTube and Facebook because I don't want to ban, but I can demonstrate that those trigger locks are no more secure, and in fact could be less and a lot less secure than a cable lock that also locks your action. So let's go ahead and we're running down to the bottom of the hour. I want to get one more story in. This one off Colorado Public Radio, or CPR.org. Concealed carry has been allowed on CU campuses since 2012, when the Colorado Supreme Court, the university system's campus gun ban, broke state law. University leaders have since stated they will respect the right of concealed carry on campus. Now, 11 years later, many students are pushing regents to review the prohibition that was in place from 1970 to 2012. A resolution passed by CU student government called for the board to discuss the issue at Thursday's meeting. The University of Colorado Boulder student body presented Rachel Hill. The University of Colorado Boulder student body president Rachel Hill urged the board to explore other options. So concealed carry has been allowed for 11 years. I can't recall a single problem that has made the media in 11 years from concealed carry. All of a sudden, the student body says, yeah, but I'm scared. And they want to disarm the ones that are there that are not causing the problem.
Yeah, I actually looked up the student body proposal or submission. I can't remember what they called it exactly. Resolution, I think. And they talked in this resolution about how students have protested the ability of people to carry concealed on campus for quite some time, and that allowing, and this is a quote from the resolution, allowing firearms on campus has and will continue to make campus community members feel uneasy. This discontent continues to today, and so that's really what this is all about, is how people feel about guns. And there's absolutely nothing of substance in this resolution. It's just a cry to make people feel better. Whether or not it actually makes them more safe, they have no idea. But they suppose that it would. But if nothing else, they just say, make us feel better.
Yeah, absolutely. We're coming down on the bottom of the hour, man. Tell everybody about Forge of Freedom podcast and how that's going for you, man.
Yeah, so I decided at the beginning of the year I would start a podcast, the Forge of Freedom. I'm an attorney, as a lot of the listeners know, and a firearms instructor, but my passion is not just the law or firearms. I really care about freedom and liberty in general. So I've started a podcast that promotes sort of a knowledge about liberty and how to defend the values and philosophy of liberty, and to promote personal responsibility. And we've got 5 episodes out now. I'm releasing weekly episodes. That may increase at some point in the future, but for now I'm going to keep it at a weekly episode. And if that's something that might be of interest to you, check it out. It's on YouTube, it's on Rumble in the video format, and it's also available in audio format from most of your podcast streaming sources. So I look forward to continuing that project. I'm going to start having some guests here soon, and I'm excited about the prospects of the podcast. Very cool. On my end, that's going to wrap up the Monday through Friday versions of the Bullet for the week. Tomorrow, Alex is back. I've also got Mike Piwowarski
joining me tomorrow. And we've got Kevin Sona. Kevin is the guy who's primarily responsible for putting together the Florida Freedom Fest that happened this past weekend in Central Florida. We'll be talking about that tomorrow at noon Central Time. That is going to wrap it up for me today. Please do come join us noon Central Time tomorrow. Thanks for watching, everybody, and we will see you